I mean, I think Minnesotans are looking for somebody to talk to about this issue. They're contacting my office. They don't know what to do. I think most people really thought that somebody else would take care of this problem. I, for one, was one of those people. I thought, this doesn't really concern me. And then, Mary, I was looking for our answer. What's our response? And I didn't see anything coming, so I started to do a little bit of legal research, and I decided, well, maybe I should speak up. I am an attorney. Maybe I can articulate the constitutional aspects of this argument and then provide the opportunity for people then to weigh in. And hopefully it's a message to our state attorney general as well, not just the people of the state of Minnesota, to our congressional delegation to stop the passage, but also to the attorney general to look out for our interests as the state of Minnesota and the residents, to make sure that our federal government does not take on illegal action against our residents and against the state under the 10th Amendment.
So are you arguing that nothing about the healthcare industry affects interstate commerce?
Not at all. But if Congress, the difference here is if Congress were going to regulate the healthcare industry, the standards, the terms, going to regulate the provision of healthcare, that would fit squarely within the Commerce Clause, but that is not what this bill does. What this bill does is forces individuals, compels them to enter into a private contract for insurance. And the Commerce Clause has never been used to regulate non-economic inactivity. That's what this is. It's inactivity, a choice not to engage in commerce. So you'll see Commerce Clause discussions in the Supreme Court about when somebody decides to farm, we can regulate when they sell their crops or how much they regulate. You can even see that they have supported the controlled substance ban on medical marijuana, right? Because somebody has engaged in a trade. But in this case, there's no trade. It's the decision not to buy something in commerce, and they've never had the power to regulate that. And the Supreme Court will strike that down as invalid. It's never happened before. There's no authority for it. And I would point out that there are much more straightforward ways to accomplish what Congress is trying to do. And the Supreme Court will always say you should not be offending the Constitution if there are more straightforward ways to accomplish your goals. And in this case, an income tax. Raise the income tax and provide subsidies for health care, or provide a tax credit with incentives for people to buy health insurance. But in this case, we're distorting the Commerce Clause to say we're going to regulate somebody's decision not to engage in commerce, which means there are no limits to the Commerce Clause if that's the case. And that's why you go back to the Constitution sets up enumerated authorities. It's a government of limited government, and whatever they don't regulate falls to the states. And that's why we can regulate things like bringing guns to within a school premise. The Supreme Court struck down Congress's attempt to regulate that, and to the Brady Bill, if you remember. They struck down the Violence Against Women Act for the same reason, that it was not economic activity. So they have been recently have been very careful to carve out the limitations on the Commerce Clause. Earlier in the last century, you saw a big expansion of the Commerce Clause. The recent Supreme Court doctrine has been to rein it back in and say, no, wait, there are limits, and what isn't taken on by the Commerce Clause is reserved to the states. I'm arguing the federal government because the state can do much in this area. In fact, if you look at GAMC and some of the things that we are trying to do, you have to wonder, if we are trying to manage this issue here in the state of Minnesota, why is the federal government going to step in and mandate an individual responsibility here? We are doing our best, and I think the Commerce Clause really is set up to acknowledge the fact that this is a local issue. It should be managed locally and not in interstate commerce.